So I will very quickly introduce our panel. Beside me is Mr. Guy Bourgon, who is a senior research advisor at the Department of Public Safety Canada and a clinical psychologist. Ms. Sue Bogle joins us. She's a Crown Counsel with the Public Prosecution Service of Canada. She practices in the Yukon. Ms. Brees, and I think I've been pronouncing your last name wrong this whole time, Davis? I'm sorry, okay, Brees Davis, defense counsel with Brees Davis Law and an adjunct professor at the University of Toronto and at Osgoode Law School. And beside Brees is Ms. Anita Parker with the Native Services Program of the John Howard Society of London and District. So we're going to start with you, Guy. You have over 25 years of clinical experience in the assessment and treatment of adults and youth involved in the criminal justice system. I know you've also worked extensively on developing and implementing empirically validated correctional programming. And I wonder if you could provide us with a bit of an overview on why people offend sexually. And can you do
Love that question, right?
Can you do it in 12 minutes?
Yeah. Before I start, I'd like to point out something that was an observation for me as I was listening to everyone this morning. The power of understanding why people behave the way they do was permeating virtually every conversation in every panel. It actually, whether we want to acknowledge it or not, guides the way we start interacting with people. Whether we're a police officer, a Crown, a defense, and how we're talking to our victims or even the offenders, this permeates everything. And we all have understandings. We all try to make sense of the world. And this question just sort of goes, hey, let's get that right on the table. And I'd start with, sexual offending is a crime. That's the starting point. And like every other crime, people who commit crimes basically know they're doing wrong. And because it's like every other crime, the causes or the factors that contribute to that is very much like every other crime. If you were to start looking at all those things, I'll just use the word sort of, you have this trait, propensity, attitude that basically breaking laws, breaking rules, violating people's rights with their personal boundaries is okay. And all we know about people who break the law, they have this to a large degree. We all have it to some degree. You know, some of us speed, and some of us, park in a no parking zone for a few minutes, but they have it much more. And that's a feature for all people who break the law. For sexual offenders, there are some, not all, who have an additional factor. Call it abnormal sexual interests or deviant sexual interests. Many of us have sexual interests, but most of us don't act on that. Now you can imagine having this propensity to violate rules and having that at the same time. That makes it very likely that what you end up doing is sexually offending. And personally, I feel a little bit of a fish out of water because I'm in corrections. Most of the stuff today has been all the front end. And in corrections, we essentially have two very primary focuses in terms of what we do. We administer a sentence. We have all that sort of administration, put them in custody, watch them over in the community. And the other sort of theme about corrections is we try to reduce the likelihood that these people who are in our care and custody are going to reoffend and create more victims. And over the last 3-4 decades, we've learned a lot about how to make that less likely to happen. And what we know is that treatment of a specific kind is really good to actually have that happen. It doesn't mean it's going to go down to zero, it's realistic, but it can make it less likely. And sort of the guiding principles to treatment is you put the right people in. Try to get those who are more likely to continue doing this. There are some who are one-off on these, there's others that continue to do this. So with limited resources, we must go after the ones that we are most likely to reoffend. We look at what are we going to target in those services. Clearly, all the factors that contribute to violating rules, bending rules, breaking the law, invading people's personal boundaries and space. Those are one of the primary targets. And if they have the deviant sexual interest, that would also be a target. The last part is to make sure that those treatment or those services are provided in a way that the clients, the offenders, will be responsive to it. We have a very diverse society, and it doesn't mean one size fits all to everyone. All of you have some experience in dealing with sexual assault, and you know not all the perpetrators or offenders are the same. Not all circumstances are the same. So we need to be able to address that and do it in a way. And what we know from the research is that it can have a substantial impact on the likelihood that these people reoffend. There's numerous barriers to actually doing this. When I say services that are effective, we still too often spend money on services that have any kind of empirical evidence that are effective. It's not services for services' sake. So we need to invest in the services that are appropriate. There are barriers from the offender perspective. Some deny their offense. Some are not motivated. Us in corrections are well versed in those kinds of people, and we have all kinds of ways in which to encourage, coerce, people into those particular treatment programs. There are resource issues. In a country as vast as ours, if you're up in the interior BC, you don't have as many resources than, say, in downtown Toronto. And those resources that are available to us are really differential depending on where you are in these communities. And there are systemic sort of barriers to this. Some of the ones that really strike me is that some of our efforts, contrary to popular beliefs, we try to do controlling strategies. And when you think of, if we just make it less likely they behave wrongly by saying, we're going to make sure you do X, Y, and Z, I go back to remember why they do it in the first place. They don't follow rules. So in spite of whatever we do to sort of circle around them so that they can't, that's what they do. That is what their propensity is. And by doing that, we're actually giving them, in essence, a reason why, well, we didn't control them enough, that's why they broke the law. And I go, where's the accountability in there? It is the offender who commits the crime who makes that choice. And if we forget about providing services to change their psychological makeup, then we've actually done a disservice to our community. Okay, a little less than 12 minutes.
Wow, impressive. I wondered, since we do still have a little bit more time allotted for you, if you can speak a little bit about what treatments or what programs do have that evidentiary background that are proven to work.
Across Canada, when I look at what's available, we have, and it depends on where you're at, there is a few. Some correctional jurisdictions have in-house programs, and that would be the larger provinces. Federally, there's COSA, which is Circles of Accountant and Support and Accountability. Our federal jurisdiction have in-custody programs. Most of the provinces don't have in-custody programs because obviously they're provincial offenders, and when they're in custody, it's a very short amount of time. Most of them are outside into the community. There's also a number of programs that are delivered by our NGOs, but again, they're sporadic and it requires enough resources to do that. Many of the programs here in Canada, because in at least the last 10 to 15 years, we're paying enough attention to go show accountability for the services that we provide. So there's at least efforts to look at and ensure that what we're doing are A, following evidence, and hopefully looking at sort of outcomes in terms of what happens to these offenders over the course of time. There is still more people than the services can provide to. The demand far exceeds the supply.
Thank you very much. Maybe we'll move on to you, Sue. And I wondered, you've been a Crown prosecutor in both Ontario and in the Yukon. Could you speak a little bit to the role of a Crown attorney in sentencing in general, and maybe go a little bit into the specifics of pertinent legislation like the Sex Offender Information Registration Act and the DNA Identification Act? And also, could you explain the Gladue principle?
Click.
Again, that's a challenging amount to speak about in a short amount of time, but I'll try my best to hit the highlights. I'd really like to thank the organizers of this event for including me as a prosecutor from the north. Small population, relatively up in the territories, but as you saw from our first set of speakers this morning, we have a very high rate of sexual assaults in the north for a variety of reasons. It's a huge problem for us up there. We're acutely aware of it, and we're working in the criminal justice system the best we can to address that high rate. And I think there's some very positive things happening up in the north as well that I'd certainly like to share with you today as quickly as I can. Being from a smaller jurisdiction, you can do certain things that I appreciate are more difficult in a larger center. One of those things, especially since I've worked in a very busy jurisdiction like Brampton, Ontario, versus now in Whitehorse, it's a lot easier in a smaller jurisdiction to have that personal interaction with the victims. I think it's a huge thing. We heard about it just now on the victim speaking about knowing what's going on ahead of time, and it's really my practice to have that interaction with the victims as much as I can, because even if they don't always like what I have to say, it's tough saying certain things. They really appreciate getting the information ahead of time as much as possible. Obviously, that's not always possible. Things happen during the course of the trial, the sentencing. But if they have that knowledge, as we say, knowledge is power, and it really, I find, helps in them undergoing the whole process. So we're at the sentencing stage now, and as you've heard during the course of the day, there's a lot of hurdles before we get to this point, sentencing, and we don't get to this point as much as we'd like. But now that we're here, what's nice for me is I don't have to say alleged victim anymore or complainant. It's the victim, and the accused is now the offender. There's been a finding of guilt, either through the trial or obviously through a guilty plea. And I do agree with some of the speakers before me. Anecdotally, I do find that there's not as many guilty pleas, although we do still get quite a few. There's not as many as there might be in other type of offenses before the court, for the reasons that we've heard up to now. But what I do at the point of the finding of guilt, or try to do, and I find that both defense counsel and the judiciary are quite responsive, is there's usually some sort of adjournment before the actual sentencing hearing takes place, and that's to gather reports. And it's important for me to talk about that because that'll bring in some of the other things that I was supposed to talk about, which is pre-sentence reports that speak of Gladue factors, as well as potentially in the jurisdiction I work in, Gladue reports that go into the background of the offender in relation to, if it's a First Nation, obviously, offender. What I also think is important is to make sure, now that we're in the sentencing process, of course, the focus is on the offender and what the appropriate sentence is going to be, but it's really important at this point if a victim wants to be part of the process, either through a victim impact statement, making a presentation to the court about how this offense has impacted them, that they have the right to be there. And if they're not there for whatever reason on the day there's a finding of guilt, I find everyone is generally very open to having the matter adjourned until the victim can be there. And I've definitely seen a change over the years, and the Victim Bill of Rights has really helped in relation to that. The judiciary is acutely aware that if the victim wants to be, that they should be a part of that sentencing hearing. So by the time of the sentencing, hopefully the Gladue report, the pre-sentence report, if they're available, the victim impact statements are before the court, and we go ahead with the sentencing. Just so I'm sure everyone here knows, obviously it's not mandatory for a victim to make a victim impact statement. It's completely optional. I still found that a lot of victims, for lots of reasons, may not want to write a victim impact statement. But often, because I've had that personal interaction, or victim services, we're very lucky in the Yukon too. We have a very proactive victim services. We have Crown Witness coordinators. They will have met with the victims and at least gotten some input from them that I can present to the court. So even if it's not a formal victim impact statement, if there's something that they want to say to the court about how the offenses impacted them, then I'll usually have that information. So at the time of sentencing, obviously I'm the Crown, I act in the public interest. As we've already heard from other panelists, I'm not the victim's lawyer. Again, that's something I explain to the victim ahead of time so that she knows that there are a lot of things that I have to present to the court. I'm acting for the public interest, which can encompass a lot of things, and it may not be exactly what the victim would want. But if the victim knows ahead of time that that's the case, I find that that's very, again, very beneficial for the victim to know this. And again, those comments by Mr. Budd about having the victim having their own lawyer or their own representative is a great thing. We don't see it that often either. We have a victim advocate that's just being put into place in the Yukon who can put forward some of those things that the victim would like presented as well. But we don't see a lot of victims that have their own lawyer. They don't have the funds. I think that would be a great practice, or if there could be some public funds for victims to have more of that, that would definitely help in the process. But as I act in the public interest, and the things that I put forward to the court in relation to a sentencing for sexual assault, 2 minutes, Section 718 of the Criminal Code, sentencing principles in these type of offenses, denunciation, deterrence, those are significant sentencing principles in most cases of sexual assault, and obviously that's something that I put forward. The other sentencing principle that obviously defense will put forward, but I also think is very important, is rehabilitation. And again, just focusing, if I have a First Nation offender and a Gladue report before me, rehabilitation is also an important sentencing principle. And really, when you think about it, I mean, if we're looking at protection of the public, as Guy was talking about in terms of treatment and counseling, if we can ensure that a person gets the counseling treatment and is not going to commit another offense, the public is best protected, that particular victim is best protected. So that's an important sentencing principle that I do emphasize as well. And really, the Gladue, for people that don't know, I have this Section 718, and I'll read it quickly just from the Criminal Code because I think it's really important. Section 718.2e, all available sanctions other than imprisonment that are reasonable in the circumstances should be considered for all offenders with particular attention to the circumstances of Aboriginal offenders. That's in the statute, Criminal Code. It's being said again, obviously in Gladue and another case, Ipoli, from the Supreme Court of Canada, 2012. A lot of people might not know, but when we're looking at the Yukon, approximately 23 to 25% of the population is First Nation, so maybe not as high as many people would think, but 70% of the prison population is First Nation. So, and I think that's fairly general across. That might be a bit higher in the Yukon, but general across Canada, and that's why those provisions were put in place. So it's a real balancing act when making submissions, because deterrence and denunciation, protection of the public are so significant in these type of sentencings. There's been lots of, if we see in the victim impact statements, pain caused to the victim's going to have to suffer that trauma, usually for a long time forward, if not for the rest of their life. But on the flip side, we have offenders, and a lot of our offenders have been, as we see from the reports, being sexually abused themselves. They're dealing with what they've seen as they've been growing up, and now they're offending as well. And we're trying to break the cycle as best we can, and how usually that plays out for sentences in our jurisdiction would be perhaps a combination of jail as well as period in the community, under community supervision, longer periods of probation, so that they can start with treatment while they're in jail and then continue on in the community getting treatment. And often that would mean even a longer period of time where they're supervised than if they just got a straight jail sentence. So that's something important that we talk to the victim about. They may see that type of sexual assault may have got 3 years in another jurisdiction, and in our jurisdiction it may get 2 years less a day, but 3 years probation. So actually the offender's being supervised for a longer period of time. And it's a challenge balancing those principles, but that's, as a Crown, that's what we try to do, try to come up with the best type of sentence to put forward to the judge that keeps obviously the pain and the suffering of the victim first and foremost, but also what will best work for the offender, that he is not back before the courts, and protect the public.
Thanks for that, Sue. So in a sort of a similar vein, I'm gonna ask Ms. Davis. You have practiced and taught criminal law in Toronto for a number of years and have experience defending individuals accused of sexual assault at both the trial and the appellate level. And I'm just wondering if you could provide us with an overview of the defense counsel's roles, or what the defense counsel's role is in the sentencing phase of a trial. And in your experience, are there specific challenges for the defense in sentencing phase in general and regarding Indigenous clients specifically?
Okay, I'm in the defense counsel seat, so I'm the third of the unwelcome guests, perhaps. Anyways, from my perspective, advocacy at the sentencing stage is just as important as advocacy at any other point in the trial, but the focus has obviously significantly shifted, because at the point of sentencing, there's either been an admission of guilt or a finding of guilt after a trial. And it's important to remember that sentencing, as the courts have told us over and over again, is an incredibly individualized process, that no two cases are the same, no two accused are the same, no two victims are the same. And so from my perspective, I think defense counsel have really two important roles at the sentencing stage, and they don't always happen after a finding of guilt or after an admission of guilt. I think they actually start from the very beginning of my retainer. The first one is sort of a more investigative role, to gather relevant information to put before the court so that the judge can determine what the fair and appropriate sentence would be in the case. And that can take a very long time, depending on the client's background and building the rapport necessary to gather the relevant evidence, and I'll come back to that. And then the second stage is more the in-court stage, where I advocate to try and convince a trial judge to craft a sentence that will be helpful to my client. And people may disagree with what that means, but I think I have a common view of what is helpful to many people in this room, which is a sentence is helpful, which is one that will ensure that my client won't do something like what they have been found guilty of doing again, and that they won't victimize someone again, and that they will change their ways, or that they will become more pro-social. So that's kind of what I see my role as. So the investigative phase of my work as defense counsel is really about changing the focus of the proceedings, because up until the point of the finding of guilt, as a lot of people have talked about, the focus is on what happened between two people, or what the events were that led to the charges. The focus is often on events. The focus is often not on the people, as we've talked about. The focus is often on the complainant, not on the accused person. But at the end of the day, it is the accused person who is going to receive the sentence. And so if there's been a trial, the trial judge may or may not know about my client. If there's a guilty plea, the trial judge will usually know virtually nothing about my client by the time the sentencing happens. They will know what the facts are, they will know what led to the offense, what the conduct was that gives rise to the finding of guilt, but they won't know about my client and what that person is. And as we all know, there's much more to any accused person than the conduct that brought them before the court for that day on the sentencing. Everybody has a story, and my job as defense counsel is to ensure that the trial judge hears as much of that story as is relevant and appropriate in terms of sentencing. And so my job is to know my client's story, to figure out how the circumstances of his life has brought him before the court. My job with the client's help is to assess what caused him to be charged, what caused him to offend, and answering that question isn't designed to excuse the behavior, isn't designed to minimize the impact on anything, but it is designed, from my perspective, to try and fashion a sentence that will address, if it can, the circumstances that caused him to come before the court. Is there past trauma in his life? Is there mental health issues? Are there addiction issues? And again, I don't say any of that to excuse anything that has happened or to suggest that what they've done wasn't a crime. I don't want to be seen that way. But sometimes we need to look at those issues to make sure that there isn't reoffending in the end. So I gather information. That can be hard. It often involves other professionals because I am not. Although I'm informed about trauma, I'm not a trauma specialist, I'm not a psychiatrist, I'm not a psychologist. I try to educate myself about the experience of Indigenous people in this country, but I'm certainly no expert in that area. So I use other experts to gather information about my clients. And I listen to my clients as much as I can to understand their experience so that I can put a relevant story to the court. It's obviously also part of my job to explain to my client what the likely sentences might be or sentence might be and what all the other orders are that they're going to be subjected to, the sexual offender registry, DNA orders, whether there'll be a Christopher's law if you're in Ontario or another provincial registration, weapons prohibitions, all that sort of thing. And then I think my job in terms of the investigative stage is to research what rehabilitative options are that are out there, both in custody, if I think that's going to be where they end up, or out of custody, because sometimes there will be an opportunity for me to advocate whether they go to the federal system, if it's going to be a term of imprisonment, or the provincial system. There are very, very, very few services available to people sentenced in the provincial systems for a whole variety of reasons, but there are obviously more rehabilitative programs at the federal level, but some of those are even being cut in terms of funding. So we need to sort of deal with that, and so I need to look at what the programs are. Okay, let me turn to the advocacy role in the last 2 minutes. So again, the target of the advocacy I do will depend on how we're getting to the sentencing stage. I may be advocating with the Crown to try and get a joint submission, or I may be advocating to the court in terms of what I think the appropriate sentence is. And my goal is to ensure that the sentence that is imposed is not punishment for punishment's sake, because I don't think that's effective for any real reason, but should focus on the underlying issues that brought the accused to court, or now the offender, and to repair the harm that's been done to the extent that we can. And I think good defense counsel should strongly advocate both of those two things in their sentencing submissions. So what are the challenges? I think there are 4, and there are probably 100, but I came up with 4. One is sentencing options have been limited by past legislative change, and we heard the minister talking about this morning, but there's no longer any option for a conditional sentence in a sex assault case, which means that trial judges are faced with a fairly stark choice between a jail sentence or a term of probation, and assuming a discharge isn't available, and those are quite rare. And so that limits the ability of trial judges to craft community-based sentences where most of the rehabilitative services are appropriate. And obviously, that creates an even bigger problem when we're talking about trying to reduce the overrepresentation of Indigenous people. So that's one challenge, that the legislation has limited the options. The second challenge, I think, is that defense counsel, although Sue talked about Crown's talking about rehabilitation, the case law is very clear that from the appellate courts across this country that deterrence and denunciation are the most important principles of sentencing in sexual assault cases. And interestingly, I think that's inconsistent with what Professor Johnson said earlier this morning about why women actually report sexual offenses in the first place, that they don't want this to happen to anybody else, which is rehabilitation, in my view, and they want people to take responsibility, which is repairing harm. Those are two other principles of sentencing in the criminal code, but the courts have repeatedly said what we should be focusing on is deterrence and denunciation, and that will always tend towards a longer custodial sentence, which again, I'm not sure will always get the rehabilitative services that we need. Third is the lack of resources for rehabilitative and restorative justice approaches to sentencing. We don't have adequate mental health services, we don't have adequate and accessible addiction services, we don't have established restorative justice programs in most places, although they're expressly provided for in Section 417 of the Criminal Code. We don't have them available, and when you don't have options available for restorative justice, you are left with and driven to concepts of deterrence and denunciation. So I think we need to put much more focus on those sorts of sentences. And then the final one, which I'm going to try and say this in a non-controversial way because I don't mean it the way that this might come across. So bear with me until I get to the end of this. I think the manner in which the criminal justice system has been scrutinized over the last number of years does create a challenge for defense counsel. Public discourse, let me be clear, public discourse around the criminal justice system is a very good thing. Nothing is right. We should always be analyzing things. We should always be questioning. But we have had a proliferation of social media with lots of opinions about particular sentences in particular cases and particular outcomes in particular cases. Often they are 140 characters long or less. Sometimes they are well informed, sometimes they are not. And so with that sort of mounting public pressure on judges and decision makers in our system, it is a challenge to convince judges to create sentences that are truly responsive to the issues that arise in these cases and are not simply punitive, deterrent, denunciatory sentences that will give rise to a very positive potential 140 character tweet. Those are my views about sentencing.
Thank you so much for that. I think maybe I'll move right on to you, Anita, if that's okay, and then we'll come back with some questions specifically for the lawyers. But Anita has a number of years of experience working with Indigenous populations who have come into conflict with the law. And I wondered if you could just briefly describe your work and your experience with the John Howard Society, and also give us some insight into what some of the cultural considerations are that the Crown and Defense Counsel and Victim Services and other criminal justice professionals should take into account regarding Indigenous victims in sexual assault cases.
Well, thank you for having me here, first of all. I think it's important to recognize the perspective that I'm coming from. It's very important not to make assumptions with Indigenous people. I have never lived on a reserve. I am a product of the 60s scoop, spent some time in some foster care, et cetera, et cetera. I was adopted by a non-Native family. So I grew up not knowing who I was as an Indigenous person. And then sometime later in my life, I met my family and blah, 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 and I learned who I was eventually. And then I started to meet other Native people and was taken home, essentially. So that's the perspective that I'm coming from today. I've worked at John Howard for about 16 years now in the Native Services Program. First and foremost, I'm a social worker, but then I graduated from the Ontario Correctional College and I'm a probation officer as well. So I've worked in those two capacities at the John Howard Society in the Native Services Program, working with Indigenous people, either as their social worker or as their PO. So it is important that I told you that first little bit about myself at the beginning, because some of the things that I'm going to be telling you today, it's just information that I've gleaned over the years, if you might say. People have shared these things with me because, as I say, I don't know what it's like to live on a reserve. I don't know what it's like to walk in other people's shoes, not all the time anyway. And I think that's important to keep in mind for all of us. We really don't know what it's like to walk in someone else's shoes. And it's really, really important to listen and take other people's words into our hearts. When we're talking about victims of sexual violence, I think I did this in a 14 font. I don't think I need my glasses. It's really important to know what community the victim is from. It's also important to know, is the offender from that same community. A lot of our communities are quite small, and the relationships are quite intertwined. In London, for example, we're deep in the heart of Indian country. There are 3 reserves right outside of town. We've got 6 Nations, we have Walpole, we have Kettle Point, we have Moravian Town. We have a lot of Native communities around us, and we have the urban population as well. So the relationships are like this, and it's important to keep that in mind. Typically, our communities are small, unless it's 6 Nations, but our communities are small and tongues wag, and that can make it very difficult for victims to tell their stories or to even come forward in the first place. It could be, the perpetrator could be a family member, which makes things difficult. The perpetrator could be someone who's really quite prominent in the community as well. Could be chief, could be a counselor, could be a healer or an elder, someone that we hold in high esteem, and that would make it very difficult for victims to come forward and talk about their story. The same dynamics do apply if the victim lives in town, if they live off reserve. As I said, we are a close community, and often our community members, reserve community members, will move back and forth from city back to the res, city back to the res. It's quite a fluid lifestyle for some of the people that I know. And victims can face real alienation from our communities following a disclosure. They can be shunned, and family members can turn their backs on each other when a disclosure is made. And it's very important to keep that in mind. Family is very important to us, as it is to you too, I'm sure. There is the true potential for lateral violence in our communities. We know that oppressed people turn around eventually and oppress each other. Lateral violence is a real problem in our communities, and when we throw sexual violence into the mix, it becomes an even more serious problem. It's very important, therefore, to work with victims on safety planning and safety considerations, and enabling them to access appropriate supports. As far as services and supports are concerned, we know that there is a huge lack of culturally relevant and culturally meaningful services in our communities for victims of sexual violence. That's a reality. Something that I have a wish list, and I'll read it to you. We have a real need for female first responders, particularly in domestic situations or really sensitive situations such as sexual violence. So we need female police officers, EMS, crisis counselors. To me, I think that would be ideal for victims. We also have a lack of Indigenous female workers in our social service agencies, whether it's in the city or small towns, in particular sexual assault centers. Victim witness programs in courthouses. I know in London, we don't have an Indigenous worker there. I think it would be really, it's on my list. It'd be awesome if we could have an Indigenous worker in victim witness. I think it's important too, we need to recognize the diversity in Indian country. All across Turtle Island, there are so many different nations, so many different cultures, so many different ways of being and belief systems. Yes, there are common threads of truth that run between many of our nations, but a lot of our nations do things differently and have different belief systems, etc. Diversity goes as far as how assimilated we are as well. So that's important to keep in mind. One thing I do know, we may not have someone who is qualified enough to, I have 2 minutes left. What will she do if I go past 2 minutes? Let's see.
Nothing.
Oh, shoot, I just wasted 30 seconds laughing. It's important to have that support person for a victim. And even if they're not like a trained social worker or a psychologist or what have you, just being Indigenous sometimes is enough. I know when I'm walking down the street, if I see a fellow Indigenous person, it's one of those, we don't know each other, but there's a connection there. And I think when we're talking about victims, that connection is really, really important. I was going to go on and on, but I can't now, apparently. I did want to, someone mentioned the term bias today and how we all bring our biases to whatever situation it might be. Something I'd like to ask of all of you is to sort of be like a turtle and go inside and take a really, really good look. Who is in there? What makes you tick? What's in your heart? And really, really absorb that. We call that being like a turtle, going inside and looking within. And become aware of what your biases are, so that you know how you can interact with others in a healthy way. And just to sort of enhance that, I'm sure you've heard this story about the old man talking with his grandson. Some people say it's a Cherokee story. I really don't know the roots of the story, but the young fellow looked at his grandfather and he said, "Grandfather, there seems to be so much turbulence in the world, so many bad things. And why is that? What's happening?" And the grandfather said to the young boy, he said, we have two wolves inside each of us. One wolf is good. It's a good wolf, and it's full of warmth and love and caring and insight. The other wolf, unfortunately, is full of anger and envy, bitterness, nastiness. And that feeling that you're feeling right now, son, he said, those are the two wolves fighting. They're fighting within you. You don't understand. So the boy looked at his grandfather and he said, "Well, which wolf wins?" And the grandfather said, "It's the one you feed." So I'm just asking you to please be a turtle, go inside, and then determine which wolf it is you're going to feed to help make our communities healthier. Miigwech.
Thank you for that. That was a really poignant story. And I'm going to ask the lawyers to follow up to that really, really excellent request for the audience members to look inside. So this question is for Sue and Brice, but if Anita or Guy, if you have any insight, feel free to jump in. But I wanted to ask both of you, how does the Sex Offender Information Registration Act impact people found guilty of sexual assault? How does it impact the trial process from a Crown perspective? Oh, that's okay. For example, does it play into plea bargaining? How does it impact the trial process from a defense perspective? Does it increase the jeopardy of the accused? And I wondered, since we only have 10 minutes left, I'll just throw another aspect into that question. If you can speak to what kind of impacts the DNA Identification Act has on people found guilty.
I'll just speak to the SOIRA. So that's the registry, sex offender registry. It's mandatory once there's a conviction, no matter in terms of sexual assault offenses. The only thing that varies is the length. It can be from 10 years if the Crown proceeded summarily, 20, or for life if there's multiple sexual assaults. It requires the offender to register certain information. In our jurisdiction, it's with the police. They have to register their current address, their current employment. If they're going to be out of their residence for 7 days or more, just keeps up to date. They register initially, and then if there's any change, they have to go back and give that information. And every year they are required to go back and give that information again. So it's for investigative purposes for the police, and also it's been recently spoken about as preventative as well. It's not public. It's some people feel that this information is made public. There's that stigma. It's not like a community notification. It is done privately. It's only certain people that have access to that information. But I do think, in my experience, anecdotally, because it's mandatory, it is something that factors into plea negotiations. We spoke again about there not being as many guilty pleas in sexual assault cases. That is one of the reasons, because that's not something that we can bargain away. A person's going to be on that registry, and it could be for life. Usually at least 20 years. So it does factor into the negotiations, certainly. It's very difficult, though, when you have a sexual assault charge, from the Crown's point of view, to drop it down to an assault where you wouldn't be on the sex offender registry. If there's a sexual assault, it's quite true. It's a not easy thing to deal away as such. And there used to be exemptions. A judge could make an exemption, but that was changed with the legislation, and now it's mandatory.
So, so in 2012, along with other legislation that did away with judicial discretion, the previous government took away any discretion trial judges had to exempt someone for the registration in SOIRA following a conviction. And there was certainly some research done about the manner in which exemptions were being granted in sexual assault cases. So I think that's an important issue to recognize, and we want to make sure that the exemptions aren't class-based or based on other discriminatory views about whether some sexual assaults are worse than others and some people deserve protection more than others. So obviously we now have it as mandatory. The other interesting change is that it can now be used for preventive purposes. I'm not sure any of us really know what that means, but what it probably does mean is that the police are going to be empowered to do a lot more random checks on people who are on the registry. So when it was for enforcement purposes only, it could only be used for investigative purposes. It was for the investigation of a criminal offense. If it's now for preventive purposes, presumably that broadens the scope of what police can do in terms of checking on people. And I think anytime you give the police discretion, you have to be concerned about how that is going to be used and whether or not that's being used in a discriminatory way as well, whether certain people are being targeted for those sorts of added checks versus others. It has been upheld as constitutional in its previous incarnation when it wasn't mandatory and it was only for investigative purposes. There has been, as far as I know, one constitutional challenge to it in its current form in Alberta, and the decision, it's not finished yet, the case is not finished. Back in the fall, it was found that the new provisions, mandatory and preventive, violate Section 7 of the Charter. They have not yet had the hearing, as I could figure it out, to determine whether or not it was saved under Section 1 of the Charter. So stay tuned on whether or not the new provisions are constitutional or not. But I think I think there is significant stigma to this, the concept that the police can randomly show up at you have to give them everything. You have to give them all of your addresses, where you work, secondary residence. You have to notify them if you're going to be away from your residence for 7 days at a time. Like it's a lot of reporting to the police about your movements. And so the concept that they can randomly show up and check, I think, is a significant risk to people in terms of being identified as being on the registry. I think lots of different police forces deal with that in a great way to avoid stigmatization, but I think that is a risk, and so I think it's something that we'll probably see more litigation around as we go forward.